I'm going to focus really on making the invention in light of Bowman-Monsanto and perhaps in a broader sense. I'm thinking of, if I turn this into an article, I might call it something like "I blame the bean," or "the bean is the guilty one," or "It's the bean what did it." And hopefully, what I'll say in the next few minutes will explain why I'm thinking about these possible titles. Okay, basically my argument really is that the life forms are self-replicating. The faculty to reproduce is something, one of the characteristics of life, and that this character does present problems for the patent system that we need new law to deal with. We need to open up a democratic process of lawmaking in order to deal with this. I don't think the existing laws and principles quite work. Okay, now what do courts do when there's sort of disputed subject matter or difficult sort of technological issues? How do they sort of deal with this? All right, in coming to a decision. Well, I mean, I'm only really familiar with sort of common law courts, so please take what I say in that light. I would say that the court will seek to understand the relevant terminology, right? They may go by the dictionary meaning. They may go by what would a person skilled in the art understand by this term. Or they would say, we go by the ordinary meaning. What would the person in the street understand by this term? Right? And so which one they go for is likely to be affected by other considerations. Okay. Second, they may go by what they think is good policy. Right. So good policy, the patent system is supposed to incentivise innovation, so therefore we want to make sure the patent functions in that way. Alternatively, we don't want to encourage this sort of research, so we have these morality exceptions in Europe. Third, the meaning of the law. What does the statute as a whole actually mean? Fourth, what does the law intend? What is intended? That's similar to slightly nuanced here, a sort of theological approach. Fifth, what is fair? What the court considers to be fair, right? And sometimes judges will think, well, okay, I want to make this decision. How do I come to that decision, all right? And they'll find a way, all right? Right, including choosing the right definition that suits in that sense. And six is reasoning by analogy. Right? A is not the same as B, but A is like B in certain respects, so we ignore the differences and go by the similarities. So A somehow becomes B. All right. And that can, reasoning by analogy is something we all do, and some argue that's how we got out of our caves 100,000 years ago, or whenever it was we came out of our caves. That thinking is a crucial element of human thought and imagination. But that can lead, I would say, to error, including the application of case law, which doesn't really work. And I'm going to, I think this Bowman-Monsanto case does give you an example of that. Okay, so the Supreme Court in Bowman-Monsanto chose to go by the dictionary definition. And by the dictionary definition of making the invention, Bowman did make the invention. Right. And why did it come to that decision? Well, I can't say for sure, but I do believe there were considerations of what was thought to be good policy, what is the intention of patent law. I think also what is fair. And clearly, as Bowman has mentioned, they were not sympathetic towards Bowman. They thought he was a dodgy character, and we don't want him to win. Okay, they weren't sympathetic, and so they had this idea of fairness. It would be fair to Monsanto to find in their favour. Now, the Court of Appeals for the Federal Circuit directly quoted two earlier cases, right, at least two earlier cases, but two are interesting. One is a case that was not about biology, unrelated to biology. And second, they quote a similar case, the Scruggs case, which is a similar case also involving Monsanto. And what was the quote for the non-biology case? It said, this is a quote: "He constructed an essentially new article on the template of the original." Right? Did he actually construct something by planting it in the ground? I find the word actually construct a bit more limited than that. I find that a real stretch. So it is applying the precedent of an earlier case, not about biology. Right? And I find that a bit questionable for reasons which I'll make clear in a few seconds, in a minute. And then the Scruggs case, again involving quite a similar case. Monsanto was again involved in this. Monsanto won, as they always seem to do. Quote, "Applying the first cell doctrine, the exhaustion doctrine, to subsequent generations of self-replicating technology would eviscerate the rights of the patent holder." Right. Now, I think in a sense they were thinking about what is fair, and perhaps they're also reasoning by analogy in a way. But I'm struck by the word self, because self-replicating is, clearly that's something done by the plant itself, I would have thought. Okay, so now why do I think applying non-biology cases concerning making an invention to be questionable? Well, there have been some recent cases in the UK. One called ISHPSSB versus Werrett, involving a sort of device with the pieces, with parts, And at what point does reconditioning, right, or actually repairing something, actually constitutes a building, a making, a manufacturing, a making of the invention, is actually quite a tricky issue. But applying that sort of reasoning into biology, I think, just doesn't work. Right? Okay. So, so what we left with this meaning of making. What is making? Now, I think the ordinary meaning of making is either one of three things: human assembly. My son likes Lego. He'll make a plane out of pieces of Lego. That's human assembly. He definitely made that plane. Right? Followed the instructions, and he makes the plane. That is definitely making. Right. Second, industrial manufacture. Clearly, there's making going on there. And then third, use of a sort of technical production system. Clearly there is making going on there as well. Resort to the dictionary, I think, to say that replanting seed is making, I think, is reasonable in one sense, but I think is intended to create a result, which is what they wanted for the reasons that I've given. So, what is left unresolved? Well, I think the question of what degree of human control is needed for us to say the person has made the invention. Bowman, as the Supreme Court said, was not a passive observer. He wasn't. Right? He was not a passive observer. But did he do? Who did most of the work here? Was it the plant doing what plants do? Seed doing what seeds do? Or was it Bowman who did most of the work there? I suspect it's actually Bowman did much less than the natural chemical process, etc., going on in that seed. So in conclusion, I would say that these types of invention, what's happening here, the patent owners are able to retain ownership of all as physical embodiments of the disclosed invention, including those coming into existence by way of the normal reproductive faculties that are inherent to all life. Therefore, we aren't making a special case. It's not that we are not making a special case, we are making a special case. And if we want to make a special case because we think that helps patent law to do its work, its supposed work, then we should actually pass a law, a further law, to say that's what we want to do. But without that, I think we're stuck with jurisprudence and principles and laws that don't really work in the case of biology. Right, thank you.